Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning. Welcome to the April 12th, 2023 sitting of the Massachusetts Appeals Court. I'm Justice Eric Neyman. Sitting to my right, Justice Peter Sachs. Sitting to my left, Justice Christopher Hodgens. Calling the first case on our list, docket 2021 P1176, KANAGA versus MANUEL. We will hear first from Attorney Pudlow.
If it pleases the court, when you look at this case and you look at the briefs that have been filed, there's an awful lot of convolutions and permutations and various items that were included. But this case really swings on one issue. Did the appellant, pro se, actually order the transcripts and take the steps that were necessary to do so before the bankruptcy? It's our contention that this did happen. She did it, and in the process concluded that she was unable to make payment on those transcripts. So she filed a motion for a declaration of indigency. Now, the appellee in this case had started an action in Oklahoma to collect on the judgment. And as a result, she was forced to file a bankruptcy, which stayed everything in this court. And in fact, to this day, there has been no action by the Superior Court below relative to the application for indigency. But that's technically moot, Your Honors. The issue being that the transcripts are there, they're paid for, they've been there for nearly 2 years. And we've been more or less squabbling over the issue of should the appeal have been dismissed on the technicality of appellate rules 8 and 9, or did the appellant pro se sufficiently act in compliance with the rules, or basically attempt to comply with the rules properly, and did whatever necessary steps she could take at that time.
Well, counsel, it's more than a technicality, isn't it? The Supreme Judicial Court has said it's a serious misstep. It's not innocuous. It's not just a flat mistake, and it's not garden variety oversight if you don't comply with the rule.
But she did comply with the rule, Your Honor, and that's the point I'm trying to make. She applied for and ordered the transcripts. When she found out she couldn't pay for them, she filed a request for a declaration of indigency, and that's where everything stopped with the bankruptcy. And so, since that time, regardless of the fact that myself and John McHugh from New York were appointed as counsel to the trustees in bankruptcy, all these things had already occurred. It was unnecessary for us to do anything because she had complied. That's our position.
So you're talking about the appeal on the merits and her getting the transcripts in time for that?
Exactly.
Okay. But this is 2 levels removed from that, the appeal that's before us today.
I understand that, Your Honor. However, the dismissal initially, we believe, was error on the court below because she had taken these steps.
Maybe.
And this generated this appeal to put us back in the position where she can have her appeal heard on the merits.
No, there is another appeal in between.
There was a dismissal of the appeal, which was appealed, and that, I believe, is this case.
There was a dismissal of the appeal. The merits appeal was dismissed.
Correct.
You tried to appeal that. That appeal was dismissed. Now you're appealing the dismissal of the...
Correct. I understand your position, Judge.
So this is the third appeal.
It's a third-prong appeal, basically. Because, again, the appellant in this case strongly believes that the court below wasn't taking note of the fact that the transcripts were there. By the time we got to this appeal, they had been sitting there for almost 2 years now. And all they need to do is have the record assembled, and then the appeal on the merits should go forward. So what we're asking this court to do is simply find that the dismissal of the appeal was in error, and that the dismissal was in error, and consequently, the appeal should be allowed to go forward on the merits. I mean, it's pretty settled law in this Commonwealth, Your Honors, that judgments or findings on technicalities are not as favorable as those on the merits. I mean, that's prevailing law in this state, and it's our position that she has a right to have her meritorious claims heard on appeal.
Let me ask you this. As you mentioned that the transcripts were available, but I noticed on the docket there's an entry, March 19th, 2021, where it says the defendant has indicated there is one of the transcripts missing.
That's correct.
So is that transcript still missing, or is it
No.
all, okay?
Not that I know of.
But it was
my
missing at that
understanding is that
point.
all the transcripts are there, Judge.
But it was missing at that point, in March of 2021.
I don't know for a fact, Your Honor. I don't have that. Mr. McHugh was assisting at that point, and he was the one ordering the transcripts and making sure that everything was in order. And I believe he let me know that it was there. And I know that the transcript has been there for some time. They're all there.
But whether the transcripts are there or not isn't an issue that's before us, is it? It seems to me the issue is when your second appeal was dismissed on the ground that the I presume it was a statement that no transcripts were going to be ordered, wasn't timely filed. What was wrong with that?
Because the transcripts had been ordered.
No. This is the transcripts for the second appeal. When you filed the appeal from the dismissal of the order dismissing the first appeal,
Well, the only
You've gotta-
transcript, I'm sorry, Your Honor.
you've got to file a form saying either you've ordered the transcripts or that no transcripts need to be ordered.
We made the court aware of that
Wh-
they
wh-
were ordered.
Where is the form in connection with the second appeal?
Right. There is no form per se that I'm aware of in this case.
Or where is the filing that's required by the rule?
The filing was making the court aware of the fact at a hearing that the transcripts had been ordered,
For the first appeal?
and the second.
Well, and the second, where was that made clear?
It was made during the Zoom conference.
You mean the Zoom conference on the motion to dismiss or the motion to admit Pro Hoc Vice?
No, that was a separate matter. The Pro Hoc
Motion to
Vice
dismiss
is,
hearing. Understood.
and again, we believe that, again, I don't understand why the court did that, but we're not appealing that issue.
So where in the Zoom conference, is there a transcript of that?
I don't believe so. So, again, I'm here suggesting that this court, in the spirit of letting appeals be heard on their merits, look at the entire picture of this case. And again, I know in my brother's brief, there's mention of a history of delay and all kinds of other things. Again, this woman was under attack by this same plaintiff in other cases. There was a whole Norfolk case that wasn't mentioned in either brief. We didn't feel it was necessary to bring it up in our brief. But in that case, the appellant, acting in behalf of one of the members of this Community of Jesus, objected to the probate of my client's husband's will and tied up the entire estate for years until this court, the appeals court, reversed and sent it back for further action. So it's not like she's the one causing any undue delays. She's been attacked. They immediately jumped on her. They attacked her in Oklahoma. They attacked her at Norfolk Probate. She had other counsel in the Barnstable case. And so what I'm suggesting is that she wants her day in court. She had the trial. We believe there were errors in the trial below, and that this appeal should be heard on its merits. Again, understanding that the fine minutiae and technicalities of the rules may not have been completely complied with. However, substantively, this appellant made every effort on her own pro se, to do that. And we believe that she's entitled to at least be heard on that issue, on the underlying merits.
You had indicated on January 11th, 2021, you had filed a notice that the bankruptcy stay had been terminated. You would file that in Superior Court. But it doesn't say what the date was that the stay was terminated. Do you know what the date was when that stay terminated?
Your Honor, I don't. I know it was sometime in late 2021 or summertime. That's my best recollection, because I didn't get back into the case until that time.
Late 2020.
It was around the time that the Pro Hoc V motion was filed by Mr. McHugh, or I filed it in his behalf. So right around that time is when the stay was lifted as to this case.
And let me ask you this too, as I noticed in your brief on page 4, you had said this. Appellant Sheldon Manuel is a resident of Tulsa, Oklahoma. Respondent Christopher KANAGA is a leader of the Community of Jesus, identified by the media as a notorious religious cult located in Orleans, Massachusetts, hereinafter the cult. And your citation for that is 3 websites. Are those websites part of the record in this case?
No, they're not. Not at this point.
Okay.
Not for the purposes of this appeal.
Counsel, the hearing on the motion for admission pro hoc vice, at least the transcript that we have, is February 9th, 2021. So would you, based on your earlier representation, agree then that the bankruptcy stay was lifted prior to that date?
On or about that date, yes, Judge.
Okay.
If there are no further questions, I will
Seeing none,
relinquish.
thank you, counsel.
Thank you, Your Honors.
We'll now hear from counsel for the appellee.
May it please the Court, Joseph Lipschitz on behalf of the appellee, Christopher KANAGA. In this case, Ms. Manuel and her counsel have repeatedly disregarded court rules and deadlines designated to expedite appeals, resulting in the Superior Court entering into 2 separate orders, as this Court has noted, dismissing various appeals from a jury verdict obtained by Mr. KANAGA against Ms. Manuel close to 4 years ago. Now, her conduct is nothing new, as this Court recognized in Manuel versus Ford, in which they affirmed that she had committed a fraud upon the Barnstable Probate Court. The Court noted itself that she is, quote, repeatedly engaged in dilatory tactics designed to delay or avoid the proceedings and has consistently failed to comply with judicial orders, end quote. It's the same type of conduct that's at the heart of this appeal and disposes of the 4 issues that are before you, arguably. One is the review of the second dismissal order. Second is Ms. Manuel's collateral attack on the first dismissal order. 3 is her collateral attack on the jury defamation verdict. And then the last issue, of course, being our request for fees and costs. So let me jump to the second dismissal order. Judge Perino's second dismissal order dated October 18th, 2021 was clearly not an abuse of discretion and should be affirmed. On May 10th, 2021, Ms. Manuel filed her notice of appeal of the first dismissal order. That triggered the clock. May 17th, the Superior Court issued an administrative notice acknowledging the notice of appeal and telling her that she had 14 days to comply with Rules 8 and 9 and Trial Administrative Order 19-1 by either requesting a copy of the transcripts needed for the appeal or certifying that those transcripts weren't necessary. Indeed, in providing her with that notice, the court provided her with the very form that complied with the rules. All her counsel needed to do was simply check the box, sign it, and file it.
Assume for purposes of today that we accept the trial judge's or the lower court's determination that the bankruptcy stay applied and told the timing for the filing of the transcripts.
So again, I'm sorry, I'm missing your question.
Assume that
Yeah.
we agree with the trial court that the filing of the bankruptcy
Yep.
stayed the appellate proceedings
Yep.
and stayed the clock.
Yep.
Proceed with your argument with that understanding in mind, please.
Well, and let me address that specifically, given the questions to my brother. In terms of when the bankruptcy stay was lifted, it was July 8th, 2020. That's in the record site, Record 67. Moreover, in September of 2020...
Volume 1 or Volume 2 of the
I
record
believe
appendix?
that's Volume 1, Your Honor. And in September of 2020, Mr. Pudlow, as well as the bankruptcy trustee itself, filed in the Superior Court a document notifying the court of the special retention of Mr. Pudlow for the express purpose of pursuing this appeal and the fact that the stay had been lifted. That is not, there isn't a specific date. They left the date blank on it, but it's dated September blank 2020, and that's in the record R71. So as of that time, even if you want to discount the fact that the 10th Circuit has held that a bankruptcy stay doesn't impede the debtor's ability to pursue with litigation to protect her interest, by that time, the stay had been lifted. So all they needed to do was comply with the rules, which they failed to do, whether you measure it from July, whether you measure it from September of 2020, whether you measure it from November 19th, 2020, which is the date of the Pro Hoc Vici motion, or whether you measure it from February 9th, 2021, which is the hearing before Judge Pasquale. Any way you slice it, they didn't comply with the rules. Now, fast forwarding to the second dismissal order, as I was talking about before, Your Honor, she was given the form. Her counsel was given the form. All she had to do was check the box, fill it in. She failed to do so. That's what prompted the motion to dismiss, and Judge Perino's decision dismissing that appeal, finding that there hadn't been any evidence of excusable neglect on that motion. And indeed, as to that motion, neither Ms. Manuel nor her counsel submitted any affidavits trying to paint excusable neglect, nor was there any explanation on why counsel, who was specifically appointed to pursue the appeal, didn't simply fill out the form that the court had provided them and file it under 9D. So our position there is clearly that second dismissal order needs to be affirmed, and there's no basis for reversing it. Now, turning now to the first dismissal order, there's no basis to challenge, much less reverse, Judge Buckley's first dismissal order. So first, Ms. Manuel can't collaterally attack the first dismissal order given this court's order of March 7th, 2022, which limited the scope of this appeal to the appeal and review of the second dismissal order. But even if this court wants to elect to review the first dismissal order and the appropriateness of that, again, there was no discretion in entering it given the fundamental failure to comply with the rules there.
You said the order of March 7th, 2022, or do you mean the order of November 18th, 2021?
No, I'm talking about this court's order of March 7th, 2022, which limited the appeal specifically, Ms. Manuel's appeal, to the review of the second dismissal order, Your Honor.
Let me just go back to the timeline for a second. So, March 18th, 2021, you file a motion to dismiss the appeal. But the next day, there's an entry on the docket that says transcripts received, notice transcripts received. So, there were transcripts acknowledged in the possession of the clerk, right?
Correct. There were
While your hearing had not even taken place yet on your motion to dismiss, right?
There was no hearing as to the second motion to dismiss.
Okay, but we're talking about the March 18th, 2021,
Yes.
right? You filed, that motion's filed.
Yep.
The next day, there's an entry on the docket that transcripts have been received.
Yep.
Does that matter?
It doesn't matter because there was no certificate filed with the clerk that complied with Rule 9D.
But the fact that the court actually had the transcripts in its possession, doesn't that mean anything?
It doesn't, quite frankly. And in fact, we point out in the McCarthy decision where it was where the SJC affirmed the dismissal of an appeal, where counsel had sent in a letter saying, oh, I've ordered the transcripts, and the court there said, that letter doesn't constitute a certification of the transcripts being ordered that are necessary for appeal. And so our position is, even though she ordered the transcripts, that's not the same thing as complying with Rule 9D.
But you did more than order them. They actually came in, right? The CDs of the transcripts were in the possession of the court, right?
Yes, I believe so. I believe so, yes. Getting back to the first dismissal, Order 2, on the issue of measuring the failure to comply with that, Judge Buckley also laid out in detail the history of the evidence that showed that this was inexcusable neglect in terms of complying with the rules. And as I said before, whether you measure it from May, whether you measure it from July of 2020, whether you measure it from September or November 19th, 2020, or February 9th, 2021, there's no question that there was violations of the rules and inexcusable neglect, particularly in light of the fact that the counsel was retained specifically to pursue the appeal. Turning now to the arguably third appellate issue, Ms. Manuel's collateral attack on the defamation verdict. There's no basis to challenge that, much less reverse the Barnstable jury verdict. And we feel that the issues that Ms. Manuel raises in her brief, we have more than fulsomely addressed in our briefs. So absent any questions on that specific issue, we are more than happy to rest on the briefs on that issue.
Seeing no further questions,
Well,
thank you both. The case is submitted.
Thank you.